you on Saturday, and I have some sashes also to hand out. We will be in the parking lot. We stage in the parking lot of the Rand Grave, which is the bar right across the street from the recycling.
Increase the volume.
Oh.
I'm not the one talking.
And, hey, you shouldn't hear me.
Yes.
And we're supposed to start meeting there at about 10 in the morning. I don't know what we're going to do from 10 to 12, but put our sashes. I guess we'll put our sashes on and visit. But I'd love to have you march with us, and there'll be room in the pickup for approximately 6 people to sit or ride if you so desire. But anyhow, it's that gorgeous red pickup again, so.
Great, thank you. I'm Kylie Breitzman. I'm the second vice president for the league and one of the organizers of this fall's speaker series. I'm here to introduce our speaker today, Don Burnett. Don is a retired professor and past dean of the University of Idaho College of Law. We want to note that the views expressed in this program are solely his own, and we're so excited that he's here to share them. I'll give a brief description of the talk for today, and then I will turn it over to Don. So the talk for today is the Independent State Legislature, Fringe Political Theory, or Constitutional Mandate. We'll hear from Don and then open it up for questions. So if you're thinking of questions throughout, please make sure to ask them at the end of today's talk. The United States Constitution says the times, places, and manner of electing U.S. senators and representatives shall be prescribed in each state by the legislature thereof, subject to alteration by Congress. The Constitution also says each state's members of the Electoral College who select the president shall be appointed in such manner as the legislature thereof may direct. In our current hyper-partisan political climate, questions have arisen about the extent of these powers. Could a state legislature appoint the state's electoral college delegates independently from the popular vote in that state? Could a state legislature draw congressional district boundary maps and impose voting registration requirements and voting procedures, free of input or review by the executive branch or the state's courts, or even a citizen referendum? The United States Supreme Court has agreed to hear this fall a case from North Carolina testing the constitutional validity of the independent state legislature theory. So we are going to hear more about that today. I'll turn it over to you, Don.
Thank you for turning out to hear what sounds like a very technical subject. It's been described in the media lately as a blockbuster. That may be a bit of media, right? But it is a very important issue now affecting our democratic republic. We have a tendency to heavily criticize the Constitution these days. There are a lot of problems with it. It was created by human beings, after all. But let's not forget some of the good things that we want to preserve. When in what we now call Constitution Hall, the curtains were drawn back, the windows were kind of like this, signaling that the Constitution Convention had done its work. A crowd gathered at the front door of the building, and according to the anecdotal history, James Madison and Benjamin Franklin walked out. And a member of the community asked Dr. Franklin, as he called him, "What have you given us? A monarchy or a republic?" And Franklin's immortal answer was, "A republic, if you can keep it." One of the reasons that the League of Women Voters is so important is that they're devoted to keeping the republic.
Could you pull that microphone up a little bit? I'm having some trouble hearing that.
All right, thank you, Mayor.
Thank you.
Here we go. Is that a little better? Okay.
Thank you.
Keeping a republic is a task for every generation, and it calls upon us to think about what is legitimately special about this republic. I'm reminded, as I reflect on that theme, of a meeting that took place in London some 30 years ago, sponsored by the American Bar Association. It was attended by the royalty. The Queen was there, along with Prince Philip, and several members of the U.S. Supreme Court, including Thurgood Marshall, were there. And Prince Philip came up to Justice Marshall and said, "It's a great honor to have you in our country. I don't suppose, though, that you would like to hear my opinion of lawyers." And Marshall said, "Oh, that's fine. I hope you won't mind my telling you my opinion of princes." Well, as I from time to time tell civic groups and students at the law school, that's 1787 all over again. That little anecdote, which by the way had been told by Justice Kagan of the U.S. Supreme Court, who was a clerk to Thurgood Marshall. He called her Shorty, very tall in intellectual stature though. It marks the division between a society based upon privilege and status to a society based upon equality and opportunity under the rule of law. That kind of republic, if we can keep it. The Constitution resolved in a single document, extraordinarily, one of the great dilemmas facing societies. And that is that the societies tended to either involve a tyranny of the few over the many or a tyranny of the many over the few. And by dispersing power vertically as well as horizontally, the Constitution addressed the problem of tyranny of the few over the many, avoiding concentrations of power. And by its augmentation during the ratification process with the Bill of Rights, it avoided the tyranny of the many over the few, protecting the few against the imposition of values of the majority, political majority. Well, as I've said, the Constitution being very broad and illuminating in concept, does have language that we, about 225 years later, have to struggle to understand and place in context. One of those areas, subject areas, is the role of states, and particularly state legislatures, in regulating federal elections. Let me put that in a historical context. During the Revolutionary War, which of course was before the writing of the Constitution, and started before the writing of the Articles of Confederation, 13 states, self-proclaimed new states, independent of their former status as colonies, proclaimed their independence not only through the Declaration of Independence, but by the formation of what I think we would call today a treaty. These, when King George was ousted, what were these colonies? Well, they said they were states, but they also insisted that they were free, sovereign, and independent even of each other. Not really a coherent nation at that point. The Massachusetts state constitution, which I quoted in the little handout they've given you, by the way, I hope everybody either has the handout or knows where to pick it up out here, said the people of this Commonwealth have the sole and exclusive right of governing themselves as a free, sovereign, and independent state. And the Articles of Confederation, which were really a wartime pact, calling upon the colonies to agree to collaborate on matters on a voluntary basis, really found only about one thing that the colonies could agree upon, and that is they wanted to be free and independent. Not exactly a durable framework for governing a country. These articles, which sometimes get about 30 minutes or 30 seconds of attention in public school, are very important. There's things in those articles that you see echoed in the Constitution. The fact that it was adopted not by the people, but by special delegates to the wartime Continental Congress differentiates it from the Constitution that came later. Any amendment to the articles had to be approved unanimously by everybody. Not just by a supermajority, but everybody. And you could withdraw anytime you wanted to. We fought a civil war about that later. Congress had no effective means under the Articles of carrying out responsibilities on a multi-state basis. We were just parties to a multi-state treaty, like an independent set of independent nations. Congress could not, under the Articles, levy taxes. It had to get contributions from the colony/states. Couldn't impose and then enforce laws within the states. Couldn't raise money for troops and had no security apparatus. One wag said that in our country, and he's speaking about 1777, Congress can declare everything and do nothing. So the Articles fell into shambles. There was a gathering in Philadelphia, and a new Constitution was written upon the theory, which was a bit controversial at the time, that the gathering of delegates to this constitutional convention could write a new constitution. They weren't constrained only to tinker with the articles. And some people said, no, that's not right. We already entered into this, quote, treaty. Yes, the answer was, but not everybody's abiding by the terms of the treaty. We're not cooperating. We don't have interstate commerce being regulated. Various colony states are dealing independently with the Indian nations. And so if the articles are being disregarded in their intent and not enforceable in their letter, it would be appropriate under international law for us to disassociate with each other and reassociate under a new framework. That, by the way, is one of the reasons why in the teaching of civil law in the United States, most law schools, including our own here, had international law as a required subject. In most places it is now an encouraged elective, but it's not a requirement. It was required then because you had to understand international law in order to understand how these states came together and what the limitations were on their respective engagements with each other. The Constitution was written to take effect when it was ratified by the people's representatives in state conventions. You're going to hear the word state from now on a lot. The Constitution was written by and for the states in the minds of those who wrote it. Not necessarily the way we look at it today, but in the minds of those who wrote it. A minimum of 9 out of the 13 original colony states had to vote to ratify. They had various means of doing that, legislatures, special conventions, and so on, before that state would be bound by the Constitution. You had to opt in order to get the benefits of the document. If you didn't opt in, you were not part of the United States of America. In fact, when George Washington took his first oath of office, as the president he had been president of the Constitutional Convention. That's where everybody just said, well, he's going to be president of the country also. We owe him a lot. When he took that oath of office, there were only 11 states that had subscribed to the Constitution. North Carolina and Rhode Island came along later when they looked around and said it's more to our benefit than to our detriment to join the others. And the vote was pretty close in many of the states. Like 10 votes more in favor of joining the United States than against it in the state of New York. Now, wasn't everybody voting in New York? It was a delegation. But it came really right down to the last minute, the last hour of the last day. History is always viewed as inevitable. This was not inevitable. This was not inevitable. Mrs. Powell, who was the woman who spoke at the Constitution Hall and asked, what have you given us? She had the right question. It was not inevitable that we would have a constitutional republic. Nevertheless, despite the scratchy and thin process that produced the Constitution, and notwithstanding its echoes from a set of articles of confederation that really failed, it still was unprecedented in many ways, including the two tyrannies that I mentioned, but also the idea that the people would have a process by which they would participate in and approve the document by which they would be governed. I think that was unprecedented. The idea that people would agree to their own governing structure and would ratify it. One of the great lawyers of that age, James Wilson, widely regarded as one of the best in the country, one of only 6 people who signed both the Declaration of Independence and the Constitution, and one of the first appointees by President Washington to the U.S. Supreme Court, gave a speech right in the late span of time in the 17th century, 18th century, when the transition from the Articles of the Constitution was being considered. And he spoke to a crowd, a parade in Philadelphia that had come to a halt just to hear him speak. And he was expressing the sentiments of these pro-Constitution advocates. People wanted to move from the Articles to something else. And he said, as I've noted here for you, you've heard of Sparta, of Athens, of Rome, but did they, in all their pomp and pride of liberty, ever furnish to an astonished world an exhibition similar to what we now contemplate? Were their constitutions framed by those who were appointed for that purpose by the people? After they were framed, meaning the constitutions, were they submitted to the consideration of the people? Had the people an opportunity to express their sentiments concerning them? Were they to stand or fall by the people's approving or rejecting vote? That's not how law got made back in 1776 and beyond. At that time, the rule of law was viewed as the law of rulers. This was a turning point. But the Constitution continued to reflect the legacy of the Articles, especially with its emphasis upon the powers of the states, these entities that made a treaty with each other after 1776. And so it is not surprising that the Constitution's methods for choosing officers of our national government, I like to use the term national government rather than federal government because federalism is a distinct concept, but the national government officers will be chosen by the states. Well, what are the words that tell us that? And again, they're in the handout, and you heard in Kylie's introduction. In Article 1, the legislative branch, we have Section 4, Clause 1, which is sometimes called the Elections Clause, meaning federal election clause. Elections under the Constitution of the United States. And to hear it again, the times, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof. But the Congress may at any time by law make or alter such regulations except as to the places of choosing senators. The states were electing the federal officers and doing so in the minds of the framers through their legislatures. You know, there's not very much history about that, about the choice of doing it through legislatures as opposed to special commissions or conventions. But there it is, there's the language. Article 2, which of course pertains to the executive branch, and therefore to the election of the president, says in its first clause, the president shall hold his office during the term of 4 years, and together with the vice president chosen for the same term, be elected as follows. And then that takes you right to the next clause. Each state shall appoint in such manner as the legislature thereof may direct a number of electors equal to the whole number of senators and representatives to which the state may be entitled in Congress. I've added some italics there. They're not original to the Constitution, but just to point out, that's the focus of the controversy that brings us together tonight. Controversy began to exude itself into the public consciousness, even though it had been bandied about in some academic circles. When in 2000, the Supreme Court decided the case of Bush versus Gore, famous or infamous case. And in that case, the Supreme Court held that the state of Florida's county-by-county systems of recounting votes when there's a dispute in the presidential election were plagued with so many irregularities and inconsistencies. You all remember the floating chads, the hanging chads. And each county trying in its own way to count the votes. But there were so many irregularities or inconsistencies, at least in the minds of a majority of the U.S. Supreme Court, that the voters were not assured of accurate and uniform tabulations of their votes, and therefore, scholars have debated this, but the court said, therefore, these voters have been denied the equal protection of the law, which is a violation of the 14th Amendment, which says that no state may deprive any person, that means a citizen. It's important to remember when talking about immigration issues. They shall not deprive any person of the equal protection of the law. Well, it was a 5-4 decision. The Supreme Court halted the recount because it was constitutionally tainted. Matter of some conjecture among political scientists whether it really changed the result. I thought at the time, I was the dean of another law school at that time, that the U.S. Supreme Court isn't going to interfere with the state's conduct of an election. This is going to be a civics lesson for the country on the role of the states. Well, was I wrong? The Supreme Court did intervene, finding a basis under the 14th Amendment of the U.S. Constitution. And 5 members of the Supreme Court agreed with that, but 3 within the 5 also advanced another theory. They said, we agree with the majority, of which we are a part, but we also think that we should be looking at whether the Florida system is unconstitutional under the Presidential Electors Clause. As you'll remember, the Florida systems were designed in part by the legislature, but had been irregularly shaped and administered by counties. And then the Florida Supreme Court had ordered a recount because of the difficulty of tabulating the votes and the closeness of the outcome. So you had counties and you had a state Supreme Court involved in a process that the electors clause of the Constitution said is designated for the state legislature. Well, only Justices Thomas and the late Justice Scalia joined in that special concurrence. So it was not dispositive. But it was something that appellate judges do sometimes. Raise the flag of an issue. And the flag is now fluttering in a breeze of controversy. The independent state legislature theory has not been adopted by the U.S. Supreme Court. But in 2015, not long after Bush versus Gore, there was a case called Arizona State Legislature versus the Arizona Independent Redistricting Commission, in which the Redistricting Commission, which had been created by the legislature, did something that the legislature ultimately didn't like in terms of drawing district boundaries for the elections of senators or representatives, the federal elections. The Supreme Court held that the power of this districting commission in Arizona, which had been created by a citizen referendum building upon earlier legislative framework, was permissible under the federal electors clause of the Constitution. But that decision was 5-4. Justice Ginsburg authored the majority opinion, for the opinion of the 5. Justices Thomas, Scalia, and Alito dissented along with Chief Justice Roberts. So now you have 4. I don't know if it'll be the same 4 today. I especially don't know what Chief Justice Roberts' view of this might be today. But he joined in the dissent, saying, in effect, the Constitution is clear on it. The framers of the Constitution were smart people. They chose their words. If they had just wanted the state to have a role in regulating federal elections, they could have just said the state, and then any state entity carry out that constitutional responsibility, but they didn't say that. They said the legislature thereof. Well, now it's 2022. Just a few weeks ago, the U.S. Supreme Court agreed to hear an appeal in a case called Moore versus Harper. Moore is, not at the outset of the case, but is now, and may still be, I guess I'm saying still be, the Speaker of the House of Representatives of the legislature. He's purporting to speak to the legislature. And Harper is an activist, a citizen in North Carolina, was involved in a lot of political advocacy with regard to redrawing the legislative district lines, the election lines, the boundaries, after the 2020 census occurred. We had the same process here in Idaho. By the way, the process here in Idaho has worked pretty well. Whatever else we might think of state government in Idaho these days, that's a good point for us. The case in North Carolina stemmed from that state legislature's creation of a new map of districts. It didn't do it with an election commission, not at that point anyway. But the legislature just drew up some maps and said, okay, in light of the dispersion of the population in the 2020 census, here's the map. It had a highly partisan aspect to it, of course. Those who didn't like the map said it's just full of gerrymandering to benefit one political party. And over a course of history, gerrymandering had occurred on both sides of the political divide. They took their case to the Supreme Court of the state, and the Supreme Court of the state agreed with them. There is impermissible gerrymandering going on here. It not only offends the free elections clause of the state constitution, but it also contravenes some other laws of the state, and so the map has to be withdrawn, has to be redrawn. And to make a rather long story short, the legislature said, we've already drawn the map. So the Supreme Court, in essence, detailed a trial court to draw a new map. And then approved that map when it was challenged. So now you had a situation where the legislature had attempted to do something, was struck down by the state Supreme Court, and then the state Supreme Court, not the legislature, had adopted a new map to remedy the problems that existed in the legislatively adopted map. Well, it comes as no surprise that the Speaker of the House of Representatives and colleagues went right to court about that and said, this is the case. This is the case that squarely poses the question of whether the independent state legislature language in the U.S. Constitution is going to be followed or not. They were pretty energetic in their advocacy. Like most hyper-partisans these days, who think everything is an emergency, they went right to the Supreme Court and asked for a stay on the state Supreme Court's decision. And this was even before the Supreme Court of the United States had agreed to take the case. Not long ago, we had one of our law faculty members talk to us about the shadow docket. You remember that, some of you do. Well, this was a shadow docket circumstance. And 3 members of the Supreme Court were willing to issue the stay. Justice Alito, Justice Thomas, and Justice Gorsuch. A 4th member, Justice Kavanaugh, said, no, I don't think there should be a stay. I don't know if I'm going to agree or disagree about the independent state legislature theory, but it's not the kind of case that we should be deciding on the shadow docket. And none of the other justices wanted to address the case in the shadow docket, so the shadow docket was denied. And then not long afterward, the Supreme Court agreed to hear the case on the merits. Full briefing, full oral argument. This is Justice Kavanaugh suggested. Now, it takes only 4 votes of the Supreme Court to take a case, not a majority. And we don't know exactly what's on the mind of all 4. We don't know where Chief Justice Roberts is at this point. And we don't even know exactly what Justice Kavanaugh has in mind. But in dissenting from the order to deny the stay, Justice Alito laid out his views about why he thought the North Carolina legislature's appeal was meritorious. And he thought we can't keep kicking the can down the road on it. He wrote, among other things, we will have to resolve this question, meaning the independent state legislature theory, sooner or later. And the sooner we do so, the better. So the case is now pending in the U.S. Supreme Court. The U.S. Supreme Court will probably hear argument on it pretty soon, in the fall. They open what's called their fall term next week. And this case will be on the docket. It will be argued. Amicus briefs, that is, friend of the court briefs from everybody who has an opinion about this, have already flooded the clerk's office at the Supreme Court. Some of those briefs get read by law clerks. But many people who write amicus briefs are just trying to put it on their resume that they submitted a brief to the U.S. Supreme Court. And they sometimes have interesting viewpoints. But they do show that there's a lot of interest in the topic. When the argument occurs, I encourage you to look for it. It'll be publicized. I think the league might take some leadership in publicizing it. And there are a lot of services, including what's called SCOTUS blog, S-C-O-T-U-S, Supreme Court of the United States. It's a blog that follows daily what's happening in the Supreme Court, in addition to the official records of the clerk of the court, and does a pretty good job, an even-handed job, I think, of summarizing the case and the arguments that have been made on that day or a preceding day. We should all watch for this. The Republic is watching for this one. The main argument, as I see it, without predicting much, is on Moore's side, North Carolina legislature side, is literal and textual. Look at the words. Look at the word. The legislature thereof is not ambiguous. It's right there. It jumps off the page. It literally means that the legislature has to regulate the federal elections, both the elections of House of Representatives and Senators and the choice, the process by which you choose the electors who then vote for president. Clear and unambiguous. It's a simple argument. It's appealing in its simplicity. And as a kind of an extension of that, and this is where it gets a little more controversial from the North Carolina legislature viewpoint, is that this designation of responsibility to the state legislatures is exclusive. The state legislature can't share it with anybody else. The Constitution says the legislature thereof. So that rules out the state Supreme Court, like the North Carolina Supreme Court, passing a judgment on the validity of what the legislature has done with regard to shaping the election process for members of Congress and shaping the process by which electors are selected. That's a pretty remarkable argument, that the state legislature in this particular subject area, unlike any other, is free from review by the Supreme Court of that state. Now, the main argument on Harper's side is that, well, yes, the word legislature is there. We see it. But the word legislature should be understood to mean whatever is the lawmaking body of the state. It's a legislative body, not necessarily limited to the legislature. That's a bit of creative verbalism. And those who argue that you don't spin wax around clear and unambiguous language are prone to dismiss that argument. But it will be made, and there are scholars who have done some research, and they think they have found some quotes from some of the framers of the Constitution that used the term legislature so freely that maybe they really were thinking just whatever is the lawmaking organ of state government, not just the legislature. A relatively, or a related argument, I should say, is, well, even the legislature is still subject to the state constitution. And we can't have the federal government, through its constitution, the national government, telling the states that their state constitution does not apply to a certain kind of act by the legislature. There's an argument on the other side that was made by Chief Justice Rehnquist and Bush versus Gore is, well, yes, it's a legislative act, it's a state body, the state Supreme Court, Florida Supreme Court in that case, has been asked to act upon it. But the state is carrying out a particular directive from the national constitution, and so that type of case is different from the ordinary stuff that comes to the state Supreme Court. Well, we will see what the U.S. Supreme Court has to say about that. And particularly whether it will say that the legislature not only has this responsibility, but exclusively has this responsibility and nobody else can participate in it. There's also kind of a practical argument, and I think to most folks, this practical argument would be appealing. And that is, suppose the legislature does have the exclusive authority to manage federal elections. Are we going to have two systems going on? You have you have election districts that have been drawn up, and all the state elections will proceed according to those maps and according to those procedures. But then you'll have perhaps another set of districts, another set of maps, and another set of procedures for the elections of members of Congress and for selecting the electors for the Electoral College to vote for president. This is going to be darn confusing, hard to administer, and create frustration among the people. And the response to it is, well, sometimes the Constitution is inconvenient. Well, that's where we are. That's where we are now. And it will be very interesting to see how the U.S. Supreme Court does with this. I'm not sure that it's a case that has political consequence, but it's not necessarily a case that has political content. This is going to be a test case for the originalism and the textual interpretation of the U.S. Constitution. Take the words as you find them and adhere to them. Or it could be a test for take the words as you find them, but then interpret them in a practical way that makes sense to people in 2022. Well, it's going to be interesting to address. I'm sorry that I didn't come here to solve this problem for you. But I think it's the task of the league to inform, not necessarily to direct. Thank you for your attention. I'll be happy to take your questions.
Thank you, Don.
Please right over there. I have a question because this is League of Women Voters, and quite a few years ago, we did something to change how we do redistricting in Idaho. I assume you're familiar with that. What would be the impact, depending on which way the Supreme Court decides, that could have in Idaho, where apparently this publicly created commission has authority that federally is limited to the legislature?
Yeah. Well, as a practical matter, if we retained, let's say after, well, I guess even before 2030, but certainly after the next census comes out, if the legislative commission would exist, which I did say I think did some admirable work, if the legislature were to adopt that, and just say, yeah, that's our opinion too, that's the way the map should be drawn, that's the process by which these elections should take place, then I don't think there's a court case. So the key is going to be, does the state legislature intend to stake out some ground different from what its commission does, or what a citizen's referendum might do, a citizen's initiative, and then try to make a federal case out of it. So that, my guess is that there are some pragmatic people in the legislature, same people who created this pretty well balanced election commission, the redistricting commission, who would say, we don't want to touch that. We don't want to be North Carolina. But if they did decide to touch it, if the Supreme Court took that textual and literal view, then it would probably say whatever the commission has done is void, and remand the matter to the state for its legislature to exercise its constitutional power.
So you can argue both ways.
Yeah, I guess so. I think there's only one correct way after the Supreme Court decides it. If the Supreme Court decides this and makes it clear, then everybody knows what the rules are. But right now, we don't know exactly what the constitutional requirement is. How broad is it? How extensive is it? And you know, in many things that were decided by the framers of the Constitution in Constitution Hall, there's a history. Yeah, I've forgotten the name of the compendium of the debates in the Constitutional Convention, pretty detailed, but there's almost nothing on this issue. It's almost as though the framers of the Constitution, following the pattern that had been established in the U.S. Articles of Confederation, and the fact that this national government was composed of independent and sovereign states, just simply didn't get into the weeds about how the states were going to discharge their responsibility. They just assumed that's the way our system works in the United States. They were pretty adamant about that. So they left it for us to figure out.
I think Zena had her hand up before I did, so.
Yeah.
Yeah, Don, you mentioned Bush v. Gore, which has always just irritated me that the Supreme Court felt they had the wherewithal to jump in and to make that decision before Florida. But now what I'm getting from your description is that that's precedent that this court might use to say that what?
Well, I wouldn't call it precedent because there was only 3 justices out of 9 who flew the flag of the independent state legislature theory. Chief Justice Rehnquist and 2 others. So it's not precedent for anything. It's just an interesting viewpoint. The Supreme Court was persuaded that this untidy process that Florida had of recounting votes and looking for hanging chads and so on was so erratic and so unreliable and so inconsistent that voters across Florida, and particularly in the counties where there's a very close tabulation, had no assurance that they were being treated, their votes were being treated equally under the law. That's where the 14th Amendment came in. The 14th Amendment was the lever for the Supreme Court to get in and undo a state election process for a federal office. So the court wasn't wrong to do that. Now, I'm not sure that the 14th Amendment would be construed the way the court, I'm not sure I agree with that. But that was the basis. The Supreme Court did also say something else that has bothered me, a little different from what we're talking about here. It itself said, these kinds of cases are so fact-specific that you have a reliable, consistent vote gathering and vote counting mechanism, that this decision is not necessarily precedential for any other case. Well, I don't like that. That doesn't sound like the rule of law to me. That sounds like a ticket for one train only. But, what do I know? I was an academic in Louisville. And I was told to say the Supreme Court is gonna give us a good civics lesson on this case. Yeah.
Don, I'm wondering, thank you so much for an excellent presentation as always, very interesting. I'm looking here at this Article 1, Section 4 Elections Clause that speaks to time, place, and manner of elections. How narrowly is manner of elections defined? Could it reach so far as to influence redistricting, for example?
Could it reach so far as to?
To influence redistricting, would Congress have an opportunity to make a law, as you say here, at any time to alter such regulations, except as to the places of choosing senators?
Right. No, that's a very good point. And that is that the Constitution did not give this regulation of federal elections authority to the state legislatures free from any congressional review. The Congress could still step in, but then you'll get into the politics of it. Does what the state legislature has done in a particular case comport with the prevailing sentiment in the Congress? And if it does, then Congress may look the other way and not undertake its authority to countermand or amend what the state legislature has done. That's when you've crossed the portal from law into politics. Well, thank you all for your attention. I hope, like students in the law school, you don't mind being let out of class a few minutes early. However, I think
I have one more
we have an
announcement.
announcement coming on upcoming events.
Yes, so next week we do not have our regular speaker series event. Instead, we have our 2 candidate forums happening first Wednesday night from 7 to 8:30 p.m. at the Latah County Fairgrounds. That'll be for the county races. And then Thursday night, October 6th, same time, 7 to 8:30, same place, Latah County Fairgrounds. That'll be for the District 6 offices. And Don will be moderating both of those events next week for us. So no regular speaker series, but we hope to see you there. Please help us spread the word. We'll be collecting audience questions throughout both evenings. Yeah.
And
Yes, might I make a brief announcement? As a member of